Welcome to Immigration Talk, a space where we hear from an expert on matters related to the immigration industry, law and policy, and practice. I'm Rosalie Van Staldeinen, and joining me is immigration lawyer Joel Sandaluk. Welcome, Joel.
Thank you.
Joel, how do the changes to the Citizenship Act affect the way that you advise your clients regarding citizenship by descent?
The changes to the Citizenship Act have actually had a really significant impact on the way that we advise certain clients. Something that we're now very aware of is that many people, particularly Americans from the northern states or other immigrant communities, for example, low German speaking Mennonites from Central or South America, might have Canadian ancestry. The changes to the Citizenship Act are significant. They follow an Ontario Superior Court decision called Bjorkquist from a couple of years ago that held that it was unconstitutional for the government through legislation to limit citizenship by descent to a single generation. So what happened at that point was there were some interim measures, but when the new legislation came into force in December 2025, the rules were such that any individual who had Canadian ancestry, any ancestry at all, would be eligible to apply for a Canadian citizenship certificate. Now, this is important because many Americans have Canadian ancestry. Many people who live along the border will have a grandparent, a great-grandparent, or what have you. And there's no generational limit for anybody who was born prior to December 2025. So what that means is if an individual from, say, upstate New York or Michigan had a great-grandparent or even a great-great-grandparent from Ontario or Quebec or elsewhere, what they would be is a Canadian citizen. That's it. A lot of people, when they call us, they confuse this type of application with a Canadian citizenship application, meaning that they're applying for Canadian citizenship. But in fact, what they're applying for is only proof of Canadian citizenship, meaning that they're already Canadian citizens. In the same way, for example, my Canadian citizenship is proven by my birth certificate. Had I been Canadian born abroad, I'd require a citizenship certificate. But all that would be is confirming the status that I already have. So it's very important to canvass these issues with your clients because obviously the process is much more easy, much more straightforward, and it can raise a lot of other options that people might not otherwise realize that they had. Now, one of the other things that's important to bear in mind is that this can also have an impact on people who are already physically present in Canada and who are subject to removal proceedings. Something that came up during the period of time between the Bjorkquist case being decided and the implementation of the new act is that immigration would issue removal orders or there would be refugee claims filed, and immigration would attempt to enforce the execution of removal orders against an individual who had a claim to Canadian citizenship. So this is also of critical importance. There's no requirement that you first obtain citizenship certificate in order to prevent the execution of a removal order or some kind of enforcement proceeding. It's only confirmation of the status that you already have. So when you're meeting with clients, one of the things that we find is that it's incredibly important to go through all of their ancestry, even if it's a little bit tedious. Once we do that, we can then speak to our clients in a little bit more detail and discuss what, if anything, they know of their Canadian ancestry and how they can obtain documentary evidence of that. A lot of the documentary evidence is relatively easy to come by. Much of it is publicly available on provincial databases or federal databases for things such as the census, or if an individual had an ancestor who, for example, had been a member of the Canadian military, a lot of Canadian military records have also been digitized. And all of these sources of information are essentially a treasure trove of documentation that individuals can use to demonstrate their Canadian status. One of the things that I'm always cautious, though, to advise clients is that once they know that they're Canadian citizens, they should simply act as Canadian citizens. They shouldn't apply for visas or ETAs to enter Canada, knowing that they're Canadian citizens and as a result have a constitutional right to leave, enter, or remain in Canada. It's of critical importance. One of the things I'm always cautious also to advise my clients, especially if they've called about themselves, is if they have any children or even grandchildren, those children are also Canadian citizens by birth. And so for a lot of individuals, it's helpful to have additional passports that provide additional options, whether it's in terms of education, employment, or just simply a place to live. One of the other things that's also very important, however, with these types of applications is explaining to people not just how they can go about acquiring their own status, but the impact on future generations. One of the limitations of the new legislation is that children who are born after the current legislation came into force in December last year, is that those children would only be Canadian citizens by birth if their parent, who was a Canadian citizen, had been physically present in Canada for a total of 3 years prior to their birth. So 1,095 days. And what this was an attempt to give meaning to some passages in the Bjorkquist decision, where one of the reasons that the old legislation was found to be unconstitutional is because there could be individuals born outside of Canada who had a real and substantial connection to Canada who would be nevertheless denied their right of citizenship. This is a way of essentially giving some meaning to that passage in the decision. So although everybody with a child who was born prior to the coming into force of new legislation, those children are Canadians, any children born after, even the siblings of the children born before, would not necessarily have a claim to Canadian citizenship. As a lawyer consulting clients, it's one more thing that you have to be alert to at the outset of every consultation, and be prepared to ask a few questions, a few relatively straightforward questions to anybody who you think it might be relevant. But of course, if it is relevant, it can completely fundamentally change the complexion of somebody's case and ultimately open doors that they might not have even realized existed previous to that.
Absolutely. Well, thank you, Joel, for sharing these practical insights regarding citizenship by descent as impacted by the changes to the citizenship law. Thank you.
It's my pleasure. Thank you.
Let's talk again.